John Brady stood before a jury and did not ask for his freedom. He asked for something smaller: mercy. He had already admitted his part in a robbery that ended in murder. His lawyer was not fighting the verdict. He was fighting the sentence. Because in Maryland, in the summer of 1958, the line between life and death came down to a single question: who actually did the killing? The story starts on a quiet road in Anne Arundel County, Maryland, on June 27, 1958. Two men, John Brady and an acquaintance named Charles Donald Boblit, needed money and a car. They ambushed a 53-year-old man named William Brooks on that secluded road. The robbery spiraled into murder. Brooks was dragged into a nearby pine thicket, and he did not walk out of it. Within days, both men were arrested and charged with first-degree murder, a crime that in Maryland at the time carried a possible death sentence. Prosecutors chose to try the two men separately, with Brady going first. On the stand, he made a calculated gamble. He admitted everything about the robbery: planning it, blocking the road, being present when Brooks died. But he swore under oath that he never intended for Brooks to die, and that it was Boblit who wrapped a shirt around the victim's neck and strangled him. His attorney's closing argument rested on that single distinction: convict my client of murder if you must, but spare him the death penalty, because he was not the one who killed. Before trial, Brady's lawyer had done exactly what a careful attorney should do. He formally requested every statement Boblit had given police. The prosecution handed over a stack of documents. Brady's attorney read them, built his defense around them, and walked into court believing he had the complete picture. He did not have the complete picture. The jury convicted Brady of first-degree murder and sentenced him to death. Boblit's trial followed shortly after, ending the same way. Brady sat on death row while his attorney kept working the case. And there, digging through the paperwork one more time, he found something that should never have been missing: a fifth statement, one Boblit had given on July 9, 1958, that had never been disclosed. In it, Boblit admitted he was the one who did the strangling. He said Brady had wanted to keep Brooks alive, and that it was Boblit who insisted they had to kill him. The prosecution had known this confession existed. They handed over several of Boblit's statements, just as requested, but held this one back: the single statement that could have corroborated Brady's entire defense, the one piece of paper that might have kept him off death row. Brady's attorney demanded a new trial. Maryland's own courts did not deny the suppression. They acknowledged it outright. But then they ruled that the hidden confession was relevant only to punishment, not to guilt, and ordered a new sentencing hearing while leaving the conviction untouched. Brady's team believed something larger was at stake, a constitutional principle bigger than one death sentence in one Maryland courtroom. They carried that argument all the way to the United States Supreme Court. On May 13, 1963, in a 7-2 decision, the court delivered an opinion that would outlast every person connected to the case. Justice William O. Douglas, writing for the majority, laid down a rule that would bind every prosecutor in the country from that point forward. The suppression by the prosecution of evidence favorable to an accused, he wrote, violates due process where the evidence is material either to guilt or to punishment, regardless of the good or bad faith of the prosecution. That last phrase is the radical part. It does not matter whether a prosecutor forgot the document existed, or judged it unimportant, or never intended to deceive anyone. If evidence favorable to the defense exists, and it could affect guilt or sentencing, the state has a constitutional obligation to disclose it. Not a courtesy, not an ethical suggestion, a constitutional requirement, grounded in the Due Process Clause of the 14th Amendment. A criminal trial, the court reasoned, is not a contest the government is entitled to win by any means available. It is supposed to be a search for truth, and hiding evidence that could clear a defendant, or soften their punishment, corrupts that search from within. In the narrow technical sense, Brady lost his appeal. The court upheld his conviction and limited his new trial to sentencing alone, exactly as Maryland's court had proposed. He was resentenced to life in prison and eventually paroled in 1974. But beyond his own case, Brady had rewritten the rules for everyone who came after him. What emerged from his loss is known today as the Brady Rule, and the evidence it protects is called Brady material. Every prosecutor's office in the United States now operates under this obligation. Fail to disclose favorable evidence and a conviction can be unraveled years, even decades later. That is exactly what has happened, again and again. The Brady Rule became one of the most powerful tools in the fight against wrongful conviction. Innocence Project cases across the country have leaned on Brady violations to free people who spent decades in prison because prosecutors buried the one piece of evidence that could have cleared them. The Supreme Court kept building on that foundation. In Giglio versus United States, the rule was extended to cover evidence that could undermine a witness's credibility, including secret deals struck with informants. The duty did not stay confined to a prosecutor's own file cabinet. It expanded to reach the entire machinery of the state working behind them. But here is the uncomfortable truth this case leaves behind. The Brady Rule creates an obligation. It does not create a foolproof way of enforcing it. It depends in large part on prosecutors policing themselves, and on defense attorneys discovering violations after the fact, sometimes only after a defendant's life has already been permanently altered. Some scholars argue the standard for what counts as material evidence still gives prosecutors too much discretion. Others note that violations are rarely punished. A prosecutor who withholds evidence and gets caught will often see the conviction fall. Their own career, more often than not, does not. What remains more than 60 years later is a strange and quietly profound idea that the government, in its pursuit of justice, is bound by a duty not simply to win, but to be honest. That a prosecutor holds a kind of trust an ordinary adversary does not, because the state does not represent one side of a private dispute. It represents the public's interest in the truth itself. John Brady never walked out of that courtroom with a triumphant reversal. His victory was quieter than that, and far larger than his own life. It was the recognition, carved into constitutional law, that a trial where evidence is hidden is not really a trial at all. It is only the performance of one.